But I think to start with and to get into all this discussion, the FCJ looked into the question whether Sisvel actually had a market dominant position, because the basis for it all is Article 102 and not the application of the Huawei ZTE decision, but it's actually Article 102 we're assessing here. Here, the FCJ explained that it's not the classical situation where you have, for example, a gas supply company, such a dominant company that is restricting access to, for example, gas supplies, and then any third party needs to go to court in order to get access. And here, the dominant company actually has a really strong negotiation position because the other one doesn't get gas or water or whatever. Here in the field of intellectual property rights and patent rights, it's the other way around. The third party, the implementer, actually has full access to the patented innovations. In particular, in case of standard cases, it's even easier because through the standard, it's very easy to implement all these patents. So easy for everybody to get access to this technology, and then it's the patent holder, it's the patentee who has to go to court basically in order to get some license fees or to stop this infringement. And that's why the FCJ in the end did confirm that Sisvel would have a market dominant position in this situation. It explicitly said that we always have to keep this in mind because this particular situation between the parties is important when assessing the further requirements with respect to FRAND. And in particular, we always have to keep in mind that it is usually not the interest really of the implementer to change the current situation where he is just using the technology for free, because you could well say that it's only going to get worse. He's going to have to start paying once he signs a license agreement, while as the situation stands beforehand, he's just using it. So the FCJ kind of assumes that as a willing implementer, you have to show that you are really willing against the odds, I would almost say, because prima facie it is not in your interest, and that's why the requirements for willingness are as high as set by the FCJ in the following, and that's the basis of all his considerations regarding FRAND.